Thank you for listening to Lone Star Community Radio. This program was broadcasted and recorded live from the LSCR studios in downtown Conroe, Texas. Lone Star Community Radio is supported by listeners like you. Donate and sponsor today. For more information on getting involved with Lone Star Community Radio, contact us at lscrstudios@gmail.com or visit us online at www.irlonestar.com.
Show. I'm Toni Collins, and I'm an attorney licensed in Texas, and we bring you a show every Tuesday at noon to discuss legal issues that have come up in the community, and I try to make them, simplify them, and give some guidance to our listeners. We're on FM 104.5 and FM 106.1 on the Montgomery County Band every Tuesday at noon. And if you missed that or you want to see the show again to pick up some legal tips, then you can go to our Facebook page, which is The Legal Connection Show, or you can get us on YouTube by just typing in The Legal Connection Show, and all of our different various shows should come up on the different topics. Or you can go to irlonestar.com and go to Legal Connection Show, and our hour-long show and the different segments are there for you to just open up and view again. Okay, so today we're going to do an additional show on a property tax protest. And that's because now Montgomery County Appraisal District, Harris County Appraisal District, Grimes County Appraisal District, Fort Bend, all the different appraisal districts are finally scheduling their tax protests, tax appeals is what they are, tax protest appeals. And basically what property owners do when they get their tax notice each year, and there is a certain time when it's supposed to be sent out, but generally it'll come out probably about March, and you have until May 15th. And then there's some wiggle room after May 15th thereafter for various reasons that you can file a late protest, and I've gone over that in different shows. But the bottom line is I'm a big advocate for protesting the tax values that are assessed on your residential or commercial property, because if you don't do that, then you're going with just what the appraisal board says. That's what your taxes are based on, which is a rate that is designated by law. And so if you don't protest the value, that's the only way you have of having any control over the tax payment that you make. And in many cases, people's homeowners, property owners, their taxes, insurance, tax insurance, what is the other one? Not interest, but taxes and insurance primarily are going to be escrowed by a mortgage company. And you don't really take notice of it until the very next year when you get this massive additional payment that is due. And it's because not that your mortgage has gone up, and of course it could be because you have an interest rate that's not, your interest rate is static. It's not, what is it? I'm losing my mind here. It's when you don't have a set interest rate, it'll float depending on what the T-bills are, or it's tied to something. But that's generally not the case. We had really low interest rates in the last few years. They're going up now because our economy is going into sort of a quasi-recession, and that hasn't been established yet. But because the inflation rate's over 9% right now, it's clear that we'll have to, the federal government has to raise interest rates to pull back the economy and get it back in check. And whenever you go into a recession type situation, and I'm not, Jim Cramer here, but the bottom line is it's cyclical, and the federal government has to raise interest rates, which of course is going to raise the interest rate that banks can loan you money on, which makes your mortgage payment higher. You can buy less house and for the same amount and what have you. So without getting into a financial legal discussion today, with regard to the economy, we're really going to be focusing on tax protest. And I went to a tax protest yesterday for my own home, And it was the first one I've actually done this year that was a formal tax protest. I'd had a couple of informals that have not been reset in Harris County and in Fort Bend and in Grimes that to be able to argue the different arguments you have to bring the value down. But there are certain things that you can argue, and you should, whether it's your residence or commercial, because it's the only way, you can control the amount of money that you're paying per month. And that's huge right now in this sort of, with gas prices as high as they are, you want to be able to save all the money that you can. And what makes it also more that you may want to entertain it for this reason is that if your neighbor has fought their taxes, then they're paying much lower for living in their house of the same value than you are because you elected not to. So it's always good to kind of get in there and kind of duke it out if you agree that the valuation is too high. The valuations have escalated almost over 100% in many areas because of the COVID. What happened was COVID brought the interest rates down, and so people could afford more house for the money because the interest rates were low. And because of that, there was a glut of people buying houses. They were all at home, and that drove the prices up for houses. So now what you have was your price of your house is valued much higher because of the economic climate of the nation drove the prices up. And because the appraisal districts value your house based on sales for that year, for an example, you're fighting right now the appraised value for 2022 because that value was set based on the sales that occurred in 2021 from January 1st to December 31st of 2021. And because all housing prices, and I don't want to say all, that's to use such a general language, but I would say 99% of the house values and property values went up due to the economy and COVID and, a myriad of reasons why they went up. They went up so high that everybody's protesting, so the taxing office was very crowded. So I'm going to give you just a little bit of background on what I went through yesterday so you can experience the same thing. Many people that were waiting, that were assigned a date and a hearing date and time yesterday, it was crowded. There was a lot of people in there. And so the people that actually had an assigned time and date were on one side, and people that didn't have that and who were at the taxing appraisal district office on Gladstone for any other reason went to go talk to somebody else. It was still very crowded. People were asked if they wanted an informal hearing, which I always opt for because I get to hear sort of their first line of argument. But if you do that, you're going to be in there a lot longer because if you don't agree with the informal offer, then you're booted back into the queue to do a formal appeal or protest. And so in my case, I asked for I didn't ask for the informal appeal. Well, in my case, the first thing they do is they send you a settlement offer via email. That's just how they function. That's the best way to do it. If you've given them that, checked off the box, you can communicate with me digitally. So they give you an offer, and it's usually nothing. It's usually $10 off what it is. Because you haven't had a chance to put your argument forward. So they're just giving you a settlement to kind of get you out of the way. I did not take that, of course. The informal settlement, when I talked to the appraisal district employee, she was maybe an assistant appraiser, but there's many of them. Talked to her in a little cubicle. She offered maybe $100 off what the appraised value was, which of course is ridiculous. And she said she showed me the 201 packet that they would have provided to me had I asked for it this year. I forgot to ask for it for my own house. I don't know why, but I got busy with all these other tax protests. So I looked at the different properties that they were using as their basis for my tax value. And of the 5 that they used, and usually there's hundreds, but they only chose 5 as the ones that they were their example ones. Only one was in my subdivision, although we had at least 6 sales in my subdivision last year, and out of 100 properties. So this was, there was a lot of sales. They used 3 in subdivisions that were miles away from my property. And the one that they did use for my subdivision was miles away from my property. And so my argument to them was, kind of twofold. One is the property that you used. Once I knew exactly which one it was. It's not a comparable property because it's got many more amenities. It's got stables and a barn and an additional house for I guess your in-laws. It had more square footage, and it was built 11 years after our house. It was much newer, and so. First it wasn't a comparable property. It was too far away within our subdivision, but we had so many properties in the new subdivision that they built behind us that were within 0.2 miles of our house. There was easily 200 that those should have been the comps that they used because that should have been the neighborhood. Well, they booted that out, and they said when I didn't agree with the informal appraisal amount they gave me, they sent me over after about an hour and a half wait with a lot of people in the waiting room talking about what had happened before and what they were arguing and that kind of thing. I finally got to the 3-board panel. And what happens is you go into a small room, which is kind of run like a court. It's got it's recorded. They swear you in. You've got the appraisal board representative who's arguing their position of value. And then you've got 3 appointed persons that are appointed by the administrative judge early in the year, and they get paid. I don't know what they get paid, but apparently they like their job and they want to go back because there's term limits for that kind of thing. And so they're really nice people, though. They had one guy that was sort of like the lead of the appraisal of the board that was appointed, and then of the panel. They're called the appraisal review board, and you get 3 people, and there's a number of them, but these are the 3 that I got. And they listen to your argument. There's a little like an overhead that looks almost like just like a sort of a modern light, and you can put your documents that is your evidence that you bring under it, and you show to this panel. You could file it in advance. You could do it over the phone, but if you did it over the phone or over Zoom, you have to file everything in advance. Over Zoom, you might be able to give it to them, but it's just easier for me in Montgomery County to do it in person because you're there talking with them. You can see their expressions, and it's just an easier thing. In Harris County, no way. I would never go there in person. I've been there in person. It is a cattle call. There are hundreds of people, and you may be in there for 8 hours before they call you. So I do it via Zoom, and I send my documents and my evidence in early for Harris County, but always ask for the 201 packet, like I didn't do for mine this time, but I was able to kind of function effectively because I knew I'd done it before. And so you show your evidence. You always want to bring evidence, and it's not evidence that you were injured unless you're arguing that you want the disability exemption, in which you're going to have a doctor's note and a lot of things for that. So it depends on what you're arguing. But if you're only arguing an unequal value or that the value is too high, of course you don't want to argue anything personal because it wouldn't make any difference. So you need to bring pictures to show that your house is structurally not as sound as the ones that they're using as their example. You want to show that your own comps. You can usually get those pretty easily through the MLS. You want to pick the best comps that you have and show why your value is lower, or the value that you have should be the one that's used, which is lower than the one that they're using, the appraisal district. And then they'll ask you what you think it's worth. Generally, when you provide your protest, they'll ask you what you think it's worth. I just happen to be just guessing. I was pretty much exactly what my argument was, and I had documents to support that amount, which was actually 100% less than what the appraised value was. So I argue that, and I think I might have been agitating them a little bit because they only want to give you 15 minutes, and I may have used 30, but I had a lot of evidence. And ultimately, they came down, they kind of met me halfway. They came down to without using numbers about what our property value is, they met me 50% down, but it still wasn't what I wanted, and it was significantly higher than what our neighbors. One neighbor, you can show unequal value, and so you want to go to what the appraised value by the district is for your neighbor's property, and you want to also use the market value. Market value is really difficult this year because all the houses were inflated to a value higher than what they were probably worth because of COVID and because of supply and demand. So unequal value would have been a better argument, and my argument was using a different neighborhood, and they were like, we're not going with that. So when I went back home last night to look, still feeling pretty successful because I got 50% knocked off of what the increase in value was. So I got quite a bit down from what they were going to value the property at. I still wasn't satisfied though. And so I went home and I looked at what our neighbors' values were at by the appraisal district, and one was significantly lower, and the other three were kind of close, and one was higher. But I still didn't like any of that because I should have been what my neighbor across the street was, which they've probably been fighting their taxes all, every year, which I hadn't been. And why that is significant. This year I'm fine. This year because I was capped out last year at a certain level. They could only raise my homestead because I have a homestead exemption. They can only raise it 10% of the actual value. And so I was pretty good for this year. The argument, I wouldn't have really argued with the value that I was paying for the actual tax amount. They had something called a loss cap. So they had it at a really high value, and they said, oh, we lost, this much in taxes because of the 10% cap. Next year, I won't be able to get that benefit unless I can argue down what the value is, because they're going to use the value that they gave me this year, which was lower, but the cap on 10% is going to be that's what they're going to use for next year. And so I'm not satisfied with that. So I looked further at what my other options were. And so that's what sort of a long way of going about what we're going to talk about on the show today. I was going to show y'all, and I didn't remember this from before, but it was the Montgomery County Appraisal Review Board showing the number of people that are actually on the board. And the 3 people that were in my board signed off on it, and I signed off on it too. And they basically it's an affidavit saying that they had not, and I'm going to read it to you. We, the members of the Montgomery County Appraisal Review Board, affirm that we have not communicated with the property owner, agent for the property owner, or an employee of the Montgomery County Central Appraisal District regarding the property that is the subject of this protest, excluding cases where the property was used as a part of the sample of the compared with other property. So basically, they're saying they don't know anything about me. They're unbiased. Well, to a certain extent, they're not unbiased because they are being paid by the Montgomery County Appraisal Review Board. And about 10 years ago, there was a big, uprising with the State Office of Administrative Hearings that they took this case saying that it was unfair that the people that you're protesting your appraisal to are actually paid by the very board that set it. And so there is some, it's still a good argument that even though they say they're not biased, they are somewhat biased because they're hired and paid by the very people that they're talking to every day. And you are the one walking into this as as a lay person, so to speak. And so I looked at the names, and I think it's really kind of interesting. I might look these people up, but for the most part, I liked them. I thought they were they seemed to kind of argue amongst themselves and in a somewhat fair way, other than they didn't have a legal argument for why they didn't reduce it more. And so I believe that I have a pretty good legal argument. So what I did before I ever, throw my, hat into the ring of filing a lawsuit against the appraisal board, not just protesting the value, I looked into it further. And so what I wanted to go over today was a couple of frequently asked questions, the way that the items that you can argue to win, and an actual case that was filed here in Montgomery County against the appraisal district that won on a legal issue in appellate court, but then it was settled out and severed when it came back down after the appellate court reversed it. So I thought that this might be some fodder for people that that aren't happy with the settlement that they offer you through email or digitally, the informal appraisal offer, if you didn't take that or you weren't happy with it, the formal appraisal hearing that you had, if you weren't happy with that. While we've gone over this in other shows, this is in a little bit more detail and a more realistic argument, not just, if you have so many properties, if it's under a certain amount and that kind of thing. This is what you probably more likely will end up doing if you want to fight the appraisal review board's set appraised value amount. But here's a couple of, if you haven't even done this yet or you're thinking about next year, there's a few frequently asked questions that I think are kind of interesting. So I'm going to ask them as though you're asking them to me. Now, if I protest my property taxes, does that mean my house is worth less? This is kind of important because if you're protesting it to make it lower, but you also want to put it on the market, you're kind of got two different sides, a double-edged sword. You want it to be lower to pay your taxes, but you want it to be higher valued to sell it. Well, the answer is no. The market value of a home is determined by recent sale in an area, not by the appraisal district's value. If you plan to sell your house, it may actively be attractive to a buyer if the taxes on the home are less. That means less out of pocket to them. So it's in your favor to fight to get it lower. And people that know real estate, including your agent, can tell you that if you successfully fight to lower the appraised value of your house, that's a smart thing to do. And it may not necessarily be what the actual market value for your house is. And that is in part because of unequal tax appraisal to even your next door neighbor. They have to treat you the same as they treat your neighbor, and your neighbor's house is not the same as yours. And so you want to argue that is the best argument is you want the right neighborhood, unequal appraised value to the general neighborhood and the people that are closest to you in that vicinity, and then the inappropriate value with regard to exemptions are because they've used the wrong comps, okay? Now, appealing my property taxes seems overwhelming. Where do I start? Each appraisal district has their own process and guidelines to help homeowners protest. And I've just told you what the Montgomery County appraisal district is. It's different in every county. Grimes County actually will call you in person to find out, to tell you what the comps are and see if you actually want to set a hearing. So it depends on the size of the county and their processes. Montgomery County, I've just explained it to you. Harris County is so large that they don't have a dog in the fight, really. It's pretty easy to fight your taxes in Harris County, but it's just more mechanical. It's not going to be so much hands-on. Now, is it risky to appeal? Can my assessed value be raised if I protest? The short answer is not really. At an informal hearing, the Central Appraisal District is not permitted to raise your assessed value, so there is no risk to you. The majority of tax protests are settled at an informal hearing. Well, I can tell you that I've never settled at the informal hearing. I've settled at the formal hearing, but the informal hearing never got me anywhere. They're just too low on the totem pole, unless you just really don't want to fight with you and want to get out of there, and you're just happy to get some small reduction. I've never gone with that. It says the next is if my property. The next question, frequently asked question: if my property is assessed for less than market value, can I still receive a reduction in my assessed value? And this is important. Yes, you can, even if you look at your appraised value and it's less than what you know the market value to be, still argue it. You can by using an unequal appraisal method. The appraisal districts permit you to compare the assessed value of your property to the assessed value of similar properties. If the similar properties are also assessed below market and your property is appraised higher than others, you are eligible for a reduction. And that's what I should have argued with my own. I didn't come with those tools. Go with those tools. Show what your neighbor's assessed value is. Even if it shows that the properties have sold in your area, the comps are good. If your neighbor is assessed lower for 2022 property values, then you have a case because that is, it is an unequal assessment. So, unequal appraisal method is high on my list right now because the sales values are not going to help you this year in general because all the prices went up. Now, when is the deadline to protest my property value? In Texas, a hearing must be submitted by May 15th of that tax year. However, on the last show, if you want to bring that one back up again, I tell you about the ways that you can get around that and still file a late protest. So go watch those old shows so we don't have to get into it today. Now, will the appraisal district inspect my house if I protest? No. The appeal process is not to put any undue time burden or inconvenience on the homeowner or the property owner. in fact, the county appraiser rarely goes into anybody's home, nor can they without your authority and a subpoena. They can't enter your home without your authority. And I certainly wouldn't. They can look on the outside, I guess, with a Google Earth that they can drive by, but they can't come into your home without permission or a subpoena or a court order. Now, if there is some condition like items like an outdated kitchen or a new roof, or typically things that show that your property is not in the same condition as the comps you're using, of course you want to provide that. Cracks, you don't have in the foundation. You've got old air conditioners. You don't have it hasn't been updated like the comps are. You don't have a generator. Of course you want to show that. So get pictures of that to show that. And that's what really helps when you get the 201 request. It's a House Bill 201 request. You normally want to get that in advance. Of course, I didn't do it with my own house this time. I've done it for all my clients. But it shows you what the comps that they're using are, and then you want to tear those apart. I didn't do it this time. I should have done that. But I knew the house anyway, and that really wasn't my argument. My argument was the neighborhood was not the correct neighborhood that they were using. The majority of protests are normal homes in good working order, and the comparable properties are used to reduce the assessed value, and they're usually not in pictures. But bring pictures, because they actually asked me about that yesterday. They were like, do you have any pictures of the homes that are our comps? And of course I didn't, because I didn't know what the comps were, because I didn't do my homework. Okay, so just a real brief review so I can get on to this case, which is really important. If you go to the comptroller.texas.gov, they've got Appraisal Review Board protest frequently asked questions. And I've gone over quite a number of these before, but the ones that I think that should help you today and would have helped me better yesterday if I'd been a little bit more prepared are issues that the ARB, which is the Appraisal Review Board, can consider to reduce your property. The first one is the proposed value of your property is too high. Ask one of the appraisal district appraisers to explain the appraisal, and they do. Verify that the appraisal reflects the correct property description, measurements of your home or business and lot, and any defects. In my case, they actually did have the proper appraised amount. You want to gather blueprints, deed records, photographs, a survey of your own measurements, statements from the builders or independent appraisers to contest the appraiser's decision. Collect evidence on recent sales of property similar to yours in the neighborhood or real estate professionals. Ask the appraisal district for the sales that it used. You've got to do that in advance, so you can't walk in and say, because you can't do the research unless you know it. Right when you get your appraisal notice, then you ask for the House Bill 201 records. They'll email it to you. If you don't have it, you can automatically ask for an extension of that hearing date until you receive it and have time to review it. You'll automatically get a first extension. More than likely, you'll get the extensions that you asked for various reasons. They don't have a problem with giving you extensions. They're so busy right now. You have to do it formally, usually either via email, or I usually do a little petition. But ask for if you don't have that House Bill 201. I wish I'd done that yesterday, and I didn't. If you protest the agricultural value of your farm or ranch, find out how the appraisal district calculated your value. I've got one I'm doing right now, and they are all over the board on that. So you really want to look at your the appraised value, get better comps than they have, get the 201 House Bill even for that, and get closer comps, because it's really just an art. It's not etched in stone. It's who's arguing to that appraisal panel the best. And in my case yesterday, I could see the appraisal panel, although they were very, very nice. They were definitely biased toward the appraisal district because that's who pays them. So kind of bear in mind, you're going to have a lot of actual evidence. They actually told me that, well, the MLS just didn't use and I was using, I'm a broker, so I had actual evidence that was reported in the MLS. And they said, well, we only had one comp for your neighborhood when I knew there was 6 for 2021. And they said, well, the MLS must not have certified it. I'm like, well, of course the MLS certified it. It's not any more certified for that property than it was for the ones that I'm using. It's, a third party that's showing which real estate agents and brokers by law have to be honest. They've sworn to being honest and to the evidence that there are the facts that they're providing to being accurate. And they've put down, this is what the sales value is and when it was sold and how many days it was on the market. That's what I used. I used it from a a resource that they use. They just didn't want to use the comps I was using. So that was, in and of itself, was pretty biased, and I've got that on the record, and I may use that if and when I decide that I'll go to the district court to argue that the appraised value was wrong. So use your own appraisals and argue that. The next is your property is valued unequally compared with other property in the appraisal district. That's what I should have argued. I should have gotten my neighbor's property that the appraisal district used for 2022 to show what they used as what they were showing for that year. I would have won hands down because they valued all of my neighbors much lower per square footage than they valued mine. The land was the same, but our land value didn't go up, which is crazy. All the land value should have gone up also. But and it may be because some of the appraisers may have lived in our neighborhood, but land value stayed the same, but the cost per square foot was completely unequal, and that may be what my case is to argue. Now, determine whether the property value is closer to the market value than other similar properties. Ask the appraisal district for appraisal records on similar properties in your area. That wouldn't have done me any good because they didn't use ones in my area, probably because it didn't help them. Is there a big difference in the values? This comparison may show that the property was not treated equally. A ratio study or a comparison of a representative sample of properties appropriately adjusted for determining the median level of appraisal must be prepared to prove unequal appraisal. You know, the different taxing groups, O'Connor, and there's several other ones. I think there's called Texas Tax Protest or something like that. These different companies, they may do that for you, but they'll charge you a lot. And of course, if they bring it down only $1, you still have to pay them. And so you may, with the money you spend in this, with the money you may save in your tax bill for that year, it's different every year, you may use on their work. And so you have to kind of do a cost-benefit analysis on that. But in my case, I know that there was an unequal appraisal to my the properties around me, and so I could still fight it if I want to. Haven't decided. Now the next one is the chief appraiser denied an exemption. This is when you ask for to have an agricultural and over 65 or disabled, and they tell you no. So you're not protesting on the property value or an equal value, an equal appraised value. You're arguing that they didn't give you the exemption you want, which is a little bit different. Typically, they will give them to you too. First, find out why the chief appraiser didn't give you the exemption you want. There's agricultural, there's timber, there's I think wildlife, there's various ones, but they're really very tedious to get them. You can't get an agricultural on your property in your subdivision if it doesn't allow you to let cattle graze as a part of the deed restriction. So that would be an untenable argument. Of course, you should be able to get your 65 and over disabled, and for them to deny that would just be you proving with your driver's license that you're the owner and you're over 65. Only one person has to be over 65. Are disabled. It's a little bit more tedious to get the disabled exemption, but the requirements are set out in the code, and so they're not difficult to get. If they're right or wrong, you're going to win if you present it to a panel and they're not being biased about it. You're certainly going to win if you take it to court, and you'll get your attorney's fees on top of it if you win by statute. So if the appraiser denies an exemption, first find out why. If the chief appraiser denied your homestead exemption, for example, obtain evidence that you own the home on the effective date of the exemption and use it as your principal residence on that date. You only have to live there for 6 months. It's a pretty easy proof burden, and generally they don't deny you on your homestead. Unless you're playing games and it's really not your homestead. So don't lie, because if you lie under oath and you're under oath, then there's a huge penalty for perjury. So don't do that either, because it's just not worth it. If the chief appraiser denied a homestead exemption for a part of the land around your home, show how much land is used as a part of your residence. You get up to 10 acres for a city, non-rural, and you get up to 200 for rural. And so I think they would be hard pressed not to give you your full residential homestead exemption if you were using it for the 10 acres. So that's I don't know why they wouldn't do that, but we didn't. I guess that's something I should look at since we have over 10 acres. But it really wasn't my argument. My argument was more on the, not using the proper neighborhood and unequal value. Because neighborhood, just so I can go a little bit further on that argument, Neighborhood is defined not by the tax code. It is defined by whatever is the reasonable definition. And there are about 10 different definitions, but primarily neighborhood is houses within the vicinity of the subject property. And so if you're borderline between two neighborhoods and they're using a tax neighborhood value for your neighborhood, let's say it's more, the properties are valued higher, and let's say that they put a much, the houses that they built in a new neighborhood are not only not comps because of the year that they were built, but that would be a reason not to have them. But the reason they should be used if they're lower value is because they're right next to your house. So your true neighbors are the ones that you can hear taking out their trash and their dogs barking, not the ones that live 5 miles away. That's not your neighborhood. So there should be an argument for that, and I haven't really looked that up because I thought for sure they were going to go with my argument because I'm an attorney and I usually don't bring an argument that's not a tenable one. Now, if the chief appraiser denied a homestead exemption for age 65 or older, disabled person, disabled veterans, spouse of a military member killed in action, or spouse of a first responder, then you just have to read about the qualifications for that exemption like you would for all of them and bring that forward to your hearing. More than likely, you're going to get that at your hearing, though. Now, let's say the chief appraiser denied or modified the assessment rating of a temporary exemption due to damage by disaster. If you disagree with the damage assessment rating determined by the chief appraiser, take evidence showing the interior of the property and repair estimates. The appraised, and we had a lot of freeze damage in 2021. So this may still be a valid argument because we're looking at property and damage from 2021 for your 2022 assessment. The appraisal district may have used one damage assessment rating for a neighborhood based on its age and building structures, which doesn't take into account unique features that are specific to your property. And there's different levels of damage, up to 100% of the total loss. So it's really important for you to look at. But look in more detail about this exemption code. Go to the Texas comptroller.texas.gov, and they've got a chart on this. If the chief appraiser denies agricultural appraisal for your farm or ranch, you want to look at the specific requirements for that. If they also do rollback taxes, if your property was used and got a tax exemption in previous years, and then you go to you buy it and now use it as your residence, they can roll back the exemption and make it a residential tax and not give you the benefit of the agricultural use exemption that was used before. And so greatly increasing the amount of taxes you're paid. They can go back 3 years on that. They can no longer charge interest on it. And they used to be able to go back 5 years, but the law changed in September of 2021. So now it's limited to 3 years and no interest on that, the rollback. But be aware of that because that can get, if you built on your house and they're looking at, using recent appraised values and they're building $1 million houses, that's a big hit. And so you definitely want to look at that pretty closely to make sure you don't get hit with that. Of course, if the appraised records show the wrong owner, wrong taxing units, property was included on the appraisal records improperly. It says some kinds of taxable personal property move from place to place. So let's say that you're now if for your personal property tax argument, you're now in Harris County and they're charging in Montgomery County. That's the kind of thing you can show them. There's just different things you can argue. But the main argument is going to be unequal treatment by the appraisal district and whether or not the comps that they used for the appraised value are incorrect. And to say that, with the formal argument is proposed value of the property is too high. Now, when you do your appraisal district appeal, you want to write all of those down, even that may apply, because you don't get a second bite of the apple. If you don't argue that up front, they'll try to say that you didn't argue, that wasn't an issue that you brought up, so you don't get to argue that issue now. So just list all of them. It doesn't hurt. You can always abandon them at the hearing. It doesn't cost you anything. So that's kind of bear all of that in mind. And I kind of stopped because I think the next part of that talked about the hearing members and stuff, and I was less interested in that. Before we get to this case, I do want to say that if you go to the Texas A&M Real Estate site, and I'm trying to see, it's called the Texas A&M Real Estate Center. They have a really good protest and appeal tax article. It was written in 2014, but it's called Publication 2062, so you don't actually even have to go to their site. You can just Google it. It's a reprint from the Tierra Grande magazine, which is associated with Texas A&M. But it talks about what you need to look at for the two big issues that you generally argue, and that's excessive appraisal and unequal appraisal. Huge things that you really need to argue. Before you argue this, if you're doing it on your own, please read this Publication 2062. I'm going to read you just a little bit of it because I really want to get on to when you appeal the appraisal review board, like I may do, and doing the analysis on whether you want to go forward with that. But here this says, in Texas, county appraisal districts determine the value of each taxable property. The annual cycle begins with the district devising an appraisal value designed to serve as the basis for calculating the owner's tax liability. As the spring unfolds, and as we were talking, this all happens, from March to about May, the property tax cycle moves from appraisal phase to the equalization phase. During the equalization phase, the property owners can review the appraised value to evaluate its accuracy. So don't just throw away that non-tax bill that came. It's something you need to look at to determine whether the taxes that you will be having to pay are based on the proper value. When the owners disagree with the estimates presented by the appraisal district, they can take advantage of remedies provided by the property tax code to adjust the appraisals that do not represent a fair assessment of their properties. Those remedies focus on two issues: market value and equal and uniform appraisals. And of course, we went over a few more that were provided to us through the tax code, but those are the big ones. The former addresses the accuracy of the value estimate, that's the comps. The later seeks to ensure that all property owners are treated fairly in the assessment process. That's what I didn't argue effectively, and I could kick myself, but I'm thinking about going to court to have a de novo review. They have to look at it completely from the beginning to look at whether or not I should have a lower assessment. Now, the first category here was the excessive appraisal value. The market value remedy may require a district court to determine if the appraised value on the appraisal district rolls exceeds the value required by law. So this is when you actually go to the district court. The court must decide if the appraisal district missed the mark in estimating property value. Typically, this determination involves teams of dueling experts, with each team producing and defending an appraisal of the subject property while criticizing the judgments and conclusions of the other experts. So you're just saying, my guy should win for this reason. It gets very expensive. That's why you do a cost-benefit analysis, whether or not you want to go to the district court. If you win, of course, your attorney's fees will be paid. If you don't, you're out a lot of money. But that's how you apply the evaluation for any lawsuit. It costs about only like $100, maybe $280 to file a lawsuit, but that's just the tip of the iceberg. You're talking about experts and evaluations and the time you're in court and worrying about it. It takes a big chunk out of your life. Now, this kind of confrontation occurs owing to the subjective aspects of deciding the, quote, market value. So you're basically asking the court or a jury, the judge or a jury of 12 people, to define it if you don't, or determine what it is if you didn't like what the appraisal board determined it to be. Definitions of market value ultimately require an estimated value that complies with the legal requirements. Official formulations contain specifications and characteristics a transaction must meet to be considered evidence of market value. Those requirements roughly distill to an amount reflecting the probable price a property would command in an open and competitive market transaction. That's why they use sales prices. But this is only in the excessive appraisal part, because you can also go down in the next segment we're going to talk about and look at the unequal treatment by your neighbor, by the taxing authority to your neighbor's property. Now, an appraisal at all levels calls for circumstances often at variance with actual conditions observed in contemporary economics. Clients intended use, principal motivations, number of competitors, and a myriad of other circumstances that can impact observed market transactions, just like an appraisal would do. And so it's almost in your best interest to get an appraiser to come out and look at your property and tell you what they think before filing suit. The problem with that is appraisals will cost you upwards to $5,000 to have an accurate appraisal done. Commercial, of course, more, but residential is also very expensive because of supply and demand. So before you do that, you want to do some of your own homework. All of these factors drive modern appraisal applications. These complicating factors guarantee that no single hard and fast formula can reliably produce a credible estimate of market value. Rather than an immutable mathematical algorithm, appraisal is an interpretive art, like we discussed earlier in the program. An appraiser is called upon to skillfully transform market information into an estimate of value for a subject property. That estimate must reflect the realities of the economic and legal environment of that subject property. The results rely on a set of assumptions and interpretations designed to capture those realities. Clearly, differences in assumptions and interpretations can produce different bottom line estimates. The court must decide which competing analysis most closely approximates the value required by the property tax code. Because that's what you're suing is the appraisal district. The court might also decide that neither appraisal is correct and therefore settle on a different value. The amount specified by the court becomes the value used to determine the property tax liability. And I will just add that we talked about this last show, but if you're going to fight the appraisal district on the value, you don't just get to not pay your taxes. You have to pay a certain appraised value each year, and the difference is what you don't pay. And that's usually either settled by a court, usually have to get a bond, but it's your right, and it's usually not over the top, but it's going to be at least what you would have had to pay in taxes based on some formula, and generally it's going to be what the tax appraisal district thought at some point that it was. And I will say that the case that I want to go over briefly today, because I know I'm going to run out of time like I always do, but it was a 2013 tax appraisal disagreement. And what happened was the people that were filing suit, and they filed suit in just like 2 years later. It was early 2016 because all this was going down in late 2013. They filed suit in the 284th Court here in Montgomery County, and their argument was kind of, to me, one that would lose, but they went forward with it in a class action, no less, with over 100 people in, I think actually it was over 500 people in 4 different courts here in Montgomery County, the 410th, the 284th, and the 9th, and one other one. And they basically said that the tax appraisal district has consistently appraised commercial properties under their market value, whereas they consistently appraise residential values over the market value, and that was an unequal appraisal. And it's still on. The court case went on for 7 years. So just get ready for a long battle. The tax appraisal board takes no prisoners. And of course, with a class action, you have a lot of people that, I think the suit was brought by a taxing group that just wanted to argue, and they took a little bit of money from a lot of people, so it wasn't an undue burden on any one person arguing it, but a whole bunch of them together had pitched in to see if they could lower their taxes this way. And it went to the appellate court, and the appellate court, the trial court found in favor of the tax appraisal district. Surprise, surprise. They're all within Montgomery County. They're all paid by Montgomery County. So that's not a surprise to me that the trial courts would find in favor of the tax group. But they found in favor of the tax group for the wrong reason. And they said that it was because that the tax appraisal group didn't bring the right theory of law before them or something. It was something, and I'm going to get to it to find out what exactly it was, but it was a theory of law that they said that they couldn't bring. And the Court of Appeals said, no, you can't argue with these people about that. They have every right to bring this case. And so they booted it back. They reversed and remanded, and it went back to the the trial courts here in Montgomery County again, which of course now you're still fighting the local government, which is really difficult, which is why the United States Supreme Court even lets you take some cases that deal with local government directly to the United States Supreme Court. You get to bypass all of the state and the county because there's so much bias involved when you're with the local government. And so in this case, though, it went back to the local court. I think it was 284th, and they ruled again against the. They ruled in favor of the taxing group and against the homeowners and their representation, because they said that you can't bring a class action suit. You have to bring it with each individual owner per the tax code, which I think may have some legal viability, some legal teeth. And so they think, I haven't looked forward, but that was not until 2021. This was set for trial in June of 2021, and it was going to go forward to a trial with that. And that was kind of all through COVID. And what happened was that I believe they severed a lot of the cases out and they were brought as new individual cases. There wasn't any res judicata there. And so anyway, you have a long road to hoe if you want to fight it. Just kind of be prepared. But if you win, you get your attorney's fees paid. So that's why you need to do this analysis. It's really important that it's worth your while and it's enough money to you from a tax standpoint to argue this. Getting the better comps is probably the best way to argue it. But unequal appraisal is what they use. But they use unequal appraisal with residential to commercial, which I think is a losing argument, when unequal appraisal really should go toward your neighbors. They appraised them unequally, and it was the same type of property. You can't say that they only owe this, per square foot tax when my house is, built 10 years before that, and you're charging me twice that per square foot tax. So there is a good argument with that. Now, this goes on to say with the real estate group that about the unequal appraisal, which is a really good argument. The Texas Constitution calls for equal and uniform treatment of property owners. That provision prohibits discriminatory practices in assessing taxes. For an example, suppose an assessor appraises sold properties at or near their sales price while leaving other properties' taxable values unchanged. Over time, disparities created by this practice would result in significantly different tax liabilities for similar properties. That was in our case. The equal and uniform provision allows property owners to protest or appeal when their properties have been appraised by a different standard than other similar properties. So look at all of your neighbors' properties. Go up and down and look at the similar properties. If the appraisal district gives them a less per square footage in 2021 and 2022, then you need to definitely argue that case because you will win on that. That means that even if the appraisal district value does not exceed market value, an owner can seek relief if the property was treated differently from other properties in the tax base. The district court must grant relief when presented with evidence providing that a subject property was appraised unequally. I mean, it is their burden, and they will not be able to meet it if you can prove that. You will win. I don't know how much you'd win, so it just depends on how much you want to fight it. The property tax code specifies the following as evidence of such appraisals. 1, the appraisal ratio for the property exceeds by at least 10% the median level of the appraisal of a reasonable and representative sample of properties in the appraisal district. So it needs to be a difference of at least 10% of properties that are similar, all right? It can't be 5%, can't be $1, but at least 10%. In our case, it was like 50%. The appraisal ratio for the property exceeds by at least 10% the median level of appraisal of a property of a sample of properties in the appraisal district consisting of reasonable number of other properties similarly situated to or of the same general kind or character as the property subject to the appeal. Boy, that is a mouthful that the lawmakers put in there. Basically, it's 10% over whatever you're looking at what your neighbors have. And finally, this is an or, so it's another one you can look at separately from the first two things we just talked about. The appraised value of the property exceeds the median appraised value of a reasonable number of comparable properties appropriately adjusted. And they didn't do that with my property either. They only used current sales. So current sales in 2021, and it should have been across the board, all properties, and looking at, when you do a ratio, if you can get the 10%. Over 10% difference. Now, the first two provisions require substantial resource to establish the appraisal ratios of a sample large enough to meet standards of statistical testing because the expense implied by those tests, many unequal appraised protests and appeals rely on a third option. some controversy has arisen concerns the specification of the code. So do read this, and it goes into a lot of detail and gives you a lot of examples. Another case was Harris County Appraisal District versus United Investors Realty Trust in the 14th District. It goes on to talk about the square footage should have been $62 per square foot, but the appraisal district used $85 per square foot. So those are the kind of things you're looking at. And then they go on to say that if it's only by 9% after using all these ratios, you're not going to win. Look at the ratios. It may be worth your while to get an expert to do it for you for the amount of money if you can win. Go to the Texas A&M Real Estate Center to look at this publication. 2062 gives you a really good format on it. I will have another show on this. It will be a part 2 on appealing to the district court because we're running out of time today. So remember to, very importantly, to serve God by serving others, and we will see you next week.